Good afternoon, all. You're very welcome to UCC. I'm going to be talking about the European agenda, and I'm going to be talking about three aspects of the agenda. But to begin, I want to talk a little bit about where Ireland and Europe fitted together in consumer law terms. And really, until the mid-2000s, for a period of between almost 20 years, we had ceded a large extent of our consumer law making to Europe. And both Sean and Brendan have referred to that issue of what's consumer law. And one reason we find it difficult, I think, to define that is because we ceded a great deal of our law-making powers to Europe. By that I mean we transposed European directives. We didn't engage in any great detail with the terms of the directive, and we basically took a European agenda on board. Now, that's something which has certainly improved in the last period. We've had a great deal of indigenous growth in the Irish consumer law area and field. So that's something which has been very, very positive. The establishment of the Competition and Consumer Protection Commission is a very exciting, as Sean has said, a very exciting development in terms of really bedding down an indigenous Irish consumer law. Other things which have been very exciting and which will be exciting in the future, the Central Bank's Consumer Protection Code, and I've given you some of the case law around that in your written paper. That has made a substantial difference in protecting consumers in the financial services area. And it has been very forward-looking. And of course, consultation has begun on a consumer rights bill for us here in Ireland, an indigenous homegrown consumer rights bill, incorporating elements of the European agenda, of course, but also dealing with the specific needs of the Irish consumer. And we are hoping that we will be seeing legislation on that matter within the next 18 months or so. So there's a great deal happening at an Irish level. Having said all of that, there's also a great deal happening at a European level. And it's really, really important for us in Ireland to be conscious of what's happening at Europe, or what's going on in Europe, for a range of reasons. What's European policy today will be Irish legislation tomorrow. There is a direct connection. So from a practical point of view, knowing what's coming down the tracks is important. But it's also important to keep an eye on things, because not everything that happens in Europe is good for Ireland. So something which I think Fidelma and I have talked about a good deal is the importance of avoiding the one-size-fits-all approach to consumer law and taking the specific needs of each jurisdiction's consumers, but obviously we're particularly interested in Irish consumers, taking the specific needs of Irish consumers on board. Sometimes what comes from Europe does not suit the Irish consumer. And we'll talk a little bit around the Consumer Rights Directive, which Fidelma will be talking about in more detail. But we'll talk about a kickback from member states in relation to that directive. I'll talk about that in a moment. But my key point is watching the European agenda is useful, because sometimes we need to fight the European agenda, we need to resist the European agenda, and we need to assert the interests of Irish consumers where they differ from the European agenda. So what I'm going to do is I'm going to take you through a little, quite briefly, the European policy agenda, how it developed, where it's at the moment, and where it's going. So I'll do that reasonably quickly. I'm then going to look at three directives. So these are now enacted at a European level, but they're about to be coming through into Ireland over the next kind of 2 years, over the next 24 months. I'm going to be looking at the ADR Directive, the Alternative Dispute Resolution Directive. I'm going to be looking at the Mortgages Directive, and I'm going to be looking at the Payment Accounts Directive. And I'll be looking at some of the issues arising from them and from transposition of these directives. And then at the very end, I'll be doing a very quick whistle stop of a number of issues which are perhaps not directly relevant, immediately relevant, but which are immediately relevant to the European consumer agenda, but which have implications and which I just want to draw your attention to. I'm going to do all of that in 20 minutes. The European agenda. European protection, consumer protection grew slowly. 5 references in the 1957 treaty. Things started to develop really from the kind of 80s on. And the policy behind the European consumer protection agenda then, and now to a degree, was market integration. So it was about economic growth. You protected consumers because then they bought stuff. And when they bought stuff, the market grew. So that was your purpose. The sort of broader social justice purpose was much less evident, certainly in the earlier directives. Now with Maastricht, which some of you will remember was a 1992 treaty, for the first time the European community, as it was, got a specific competence in respect of consumer law. And I've put up the relevant article there, and you'll see that's a little bit more social justice sounding. In truth, however, after the Maastricht Treaty, most consumer protection directives have still really had that market integration underlying policy. That's shifting a little bit. One of the directives I will talk about, I will suggest, has more of a social policy consideration. So that underlying policy is shifting a little as things are developing. Now, while Maastricht didn't hugely change the underlying policy and the underlying emphasis on market integration, getting people to buy stuff, there were important legal changes in the post-Maastricht environment. And the main point here, I suppose, and this is a picture, Declan will recognise it, of the, and many of you will, of the Commission building. It's hard to know it's any building really when you look at it there, but it is the Commission building, or so Google said. So the Commission began to develop became increasingly concerned because that's intended to be a picture of gold plate. They became particularly concerned because consumer protection measures were being used as a form of gold plating, as an anti-competitive measure. And this arose in the context of the fact that most of the earlier consumer protection directives were minimum harmonising directives. So they set the bottom level. And then member states could pile on their own protections over that bottom level. And of course, member states did, sometimes because they loved consumers and wanted to make life easier for them and better for them, and sometimes because they wanted to keep other entrants out of the market, hence the gold plating idea. Now, naturally, the Commission was not particularly happy with this. And one of the other things which the Commission was unhappy with was a review of directives. And any of you who have struggled through directives, I suspect, will agree with the Commission, noted that they're generally not terribly well written. It's generally not entirely easy to know what exactly has been got at. They reflect inevitably the tensions which arise where you've got different legal systems interacting with each other. So out of this, the Commission began to develop moves really to address particularly the gold plating concern. And they started to move towards maximum harmonising directives. So in other words, the Commission would set not the bottom level, but the top level, the point beyond which member states couldn't go. Now, from a consumer protection perspective, this is not by any means unadulteratedly good news. Works well from a competition perspective, but from a consumer protection perspective, the difficulty with this is obviously in states which have very developed consumer protection laws, you were looking at a reduction in consumer protection. And in fact, here in Ireland, if you look at our Consumer Protection Code, which is introduced by the Central Bank, two of the minimum harmonising directives actually mean that consumers covered by the directives get less protection. In other words, the ones who are deemed needing protection actually get less protection than those who are not covered by the directive, because the protections we offer under the code are actually greater than the European protections. And of course, they were two maximum harmonising directives. So from a consumer perspective, maximum harmonisation is not something which I think Fidelma and I would certainly suggest should be embraced with open arms at all times. And we will talk further about how things have developed. Member state fight back. That is the Battle of Trafalgar. It's a rather blurry Battle of Trafalgar, and I'm not sure if French and British battle was the most appropriate one to put up there. But anyhow, that's the one I chose for member state fight back. Because member states, particularly in the discussions around the Consumer Rights Directive, began to essentially reassert member state autonomy in respect of consumer law. The directive, which was originally proposed, was very extensive. It would have, for us in Ireland and in the UK, removed the right to return faulty goods, among other things. The directive had a very wide-ranging set of provisions, and it was maximum harmonising. It was going to set the top scale. Member states, including our own through the Department of Jobs, Innovation and Enterprise, and the work of the Sales Law Review Group, fought back or basically said to the Commission, this won't work. And this, I think, is the kind of very healthy dialogue that is absolutely essential in developing European policy, that the Member States contribute and fight back against European policy if it's not going to work for them. The final directive, and Fidelma will talk about its transposition into Irish law, is very different from that originally proposed. In relation to sales, much of the original proposals are they're gone from the directive, or many of the original proposals, I should say. Fidelma will talk about the specifics later. There is work ongoing on developing a regulation on consumer sales, although which will apply just in cross-border context, but how that's going is something we have to wait to see. To a degree, I think the Commission has learned a lesson. They are being more careful. We are still seeing maximum harmonising measures coming out, but we are seeing more potential for member state derogation. And you'll see that when we look at the couple of directives that I'm going to be looking at in a moment, the hard examples, as it were. There are quite a lot of areas which are left to member states. So whilst you have a directive which looks ostensibly as a maximum harmonising measure, when you actually dig down into the directive, there are quite a lot of choices left at member state level. And I would see that as something of a retrenchment by the Commission from that maximum harmonising attempt. In terms of the current agenda, and I know Sean has spoken about that, I'm just giving you the sectors which have been identified there. These are the areas that the Commission is particularly interested in focusing on. You may find it difficult to ascertain what they are from my pictures, but I'll tell you. Digital, the digital sector, the transport sector, the energy sector, the misleading environmental claims sector, which is not a sector I recognised until about 2 days ago when I was looking at this, but apparently it's big. There's a lot of issues in misleading environment, telling you things are green and they're not. And of course, my own favourite, the financial services sector. So that's basically where the agenda is going to focus over the forthcoming period. Okay, to take you through some of our directives. Now, these are directives which have been passed and which are coming into, will be transposed into Irish law over the forthcoming period. First one is the ADR Directive, Alternative Dispute Resolution. The idea here is to facilitate and encourage the use of alternative dispute resolution. This comes really from a view of consumers as finding it more difficult to assert their rights. And there's quite a literature on this, why consumers find it more difficult to assert their rights. And in light of the figures which Sean just cited, it's very clear that there are breaches of consumer rights happening all around the place, and consumers don't seem to be very good at asserting their rights. And there are all sorts of reasons for that. One solution, and it's a solution very much being put forward by the Commission, is the development and enhancement of alternative dispute resolution, and using that as an alternative to court procedure. And that's where the ADR Directive has come from. Now, the current position, because until mid-2015, ADR is covered by a couple of Commission recommendations. And as you all know, recommendations do not have legal force, so they're not legally binding. The principles you'll see there, so basically this is the Commission saying we'd like you to do this. The principles you'll see there, independence, transparency, effectiveness, legality, all of those have now been put on a statutory footing. And they're all now written into the new directive. Here's the new directive. It's the ADR Directive. Came out last year, and it has to be transposed by the 9th of July 2015. The Department of Jobs, Enterprise and Innovation has published a very useful consultation paper on the ADR Directive. I find it exceptionally useful because it sets out very neatly, so look at the department's website if you want to have a look at it. It sets out very neatly all the questions which the state has to consider in transposing. And you'll see there's a lot of questions for the state to consider, which really reinforces that notion of maximum harmonising, but with quite an amount of state discretion. So I would certainly recommend, if you're interested in this area, to have a look at that. In terms of what the directive is going to do, it's going to apply to all ADR, binding and non-binding. So that's something to watch. It's going to apply to domestic and cross-border ADR. So that's something which is worth being aware of. There's a two-pronged approach taken in the directive to encourage us to use ADR. You've got provisions on availability and accessibility, and that's going to be a big one coming down the tracks. And then you've got procedural requirements for how ADR will have to work. Now, in relation to both of those prongs, there are choices. There are choices at a member state level. Okay, member states, in terms of something which there isn't a choice on, member states are required. So we don't have a choice on this. We have a choice about how we do it, but we are required to ensure that consumer disputes can be covered, which are covered by the ADR Directive, can be submitted to an ADR entity which complies with the requirements of the directive. One of the questions which the department asks is, do we have such an entity now? And I would say no. In the financial services field, we certainly do. In the pensions field, we certainly do. We've got ombudsmans there. But beyond that, our ADR facilities are, I would suggest, limited, and we've got to do something about that before 2015. In terms of accessibility, the directive leaves a fair amount to member states in terms of how accessible the scheme will be, or how to what extent, the pervasiveness, I suppose I should say, of the scheme. The scheme has to apply, or the schemes have to apply to domestic and cross-border disputes. But, and some would suggest this is a problem, there is no requirement on states to require traders to participate in ADR. States can. So, for example, in the financial services field, a financial services provider has no choice but to participate in the Ombudsman scheme. But there's no requirement for that in the directive, but we can. So one of the choices which Ireland can make is to introduce mandatory participation in ADR on traders. So that's a big choice coming down. In terms of procedural requirements, and some of you, particularly those in practice, will be interested in these. Requirements in relation to impartiality, in relation to all ADR entities, and we're going to have new ADR entities, that's going to happen, have to be impartial, have to be transparent, they've got to publish their terms of reference. In the written paper I've given you much more detail on this, but I'm just kind of working through it quite quickly here. They all have to publish annual reports. They have to be effective, and for those of you in legal practice in particular, I want to draw your attention to a couple of requirements. There cannot be a requirement for legal representation, but equally there cannot be a prohibition on legal representation. So if consumers choose to use a legal representative, that cannot be prohibited by the ADR entity. The big interesting one is a time limit of 90 days will be imposed. So ADR entities, and this could be interesting from a financial services ombudsman perspective, ADR entities will have a time limit of 90 days. They have to be fair, and there are various other procedural requirements which I've detailed in the paper. Okay, the other issue is who enforces. Who's going to enforce the ADR directive when it gets transposed? There has to be a designation of a competent authority, and that's going to be an interesting one. I would assume the Competition and Consumer Protection Commission will be designated a competent authority. The more interesting question is whether the central bank will also be designated a competent authority. At the moment in Ireland, as many of you will know, we have this dual system in terms of consumer protection, where the central bank basically does the financial services consumer protection and the Competition and Consumer Protection Authority does the other. If we end up with two competent authorities, which I suspect is likely, although I don't know, it would be really, really important, not just in this context, but it's a hugely important factor in general, that they can talk to each other. I don't mean that they're nice to each other, but I do mean that they actually have mechanisms to ensure cross transfer of knowledge. And that's a huge issue because we do and have developed two systems at the moment, and that interaction is absolutely key. There's also proposals for penalties, etc. Okay, I want to talk quite quickly about online dispute resolution, which is something which was new to me when I first encountered it a couple of years ago. I don't know if many of you are familiar with it. The idea is you do your dispute resolution. It's alternative dispute resolution, so you have negotiation, you have mediation, you have the works, but you do it all online. The idea is to take the personal out of negotiation. Now, there's good and bad to that, obviously, as I presume you'll all be aware. It has advantages in that it is argued that you have programs which will ensure that, for example, language use is toned down, thus facilitating negotiation, facilitating reaching a settlement. So you have all sorts of clever technological tricks to facilitate negotiation. I'm not going to, I haven't the time, sadly, to talk about them to any huge extent. My main interest is to draw your attention to the fact that this is something which is very much on the European agenda. At the same time as the ADR Directive was given effect, an online dispute resolution regulation was introduced. As you know, regulations have direct effect. It works alongside the ADR Directive, and basically what it's going to do is establish a European online dispute resolution, or ODR, platform. And that's going to start, I'll just give you the dates and I'll run back quickly then. Testing on that platform is going to start next January, and it should be up and running by January 2016. So the idea of this, and it very much fits the European model, which is a concern at cross-border, encouraging cross-border trade. We don't cross-border trade anything like the amount the European Commission would like us to. And one of the reasons is if you buy something from another member state and it goes wrong, we know our chances of redress are very restricted. The idea of this model is to encourage us, to make us feel better, particularly in the e-commerce market, to get us transacting online with more enthusiasm. A lot of disappointment at how slowly the e-commerce cross-border market has developed. It's been slow. Okay, in terms of how it's going to work, this is what the regulation requires. There'll be an own language facility. There'll be no submission fee. Traders won't have to participate. So there's not going to be an obligation on traders to participate, although member states can require that. So again, Europe isn't, but member states can, coming back to this notion of leaving choices at member state level. To put it fairly simply, the idea will be consumer completes an electronic complaint form, transmits it, to the complainant comes back and they agree to an ADR entity, and then the ADR entity solves everything within 90 days, and it's going to be lovely. I don't know how well it's going to work. My own sceptical self says, all very well, but what about enforcement? You know, enforcement, it's all very well to have your nice agreement, but how are you actually going to enforce this? But maybe if traders buy into this, you will have traders who will be prepared for PR reasons to go along with it. But that's the model, and that's what's coming. Okay, the next directive I want to draw to your attention is the Mortgages Directive. And as you know, most people could write books, and several people have, on who was responsible for the financial crisis. But one set of people who are certainly seen as being responsible are those who lent on home loans, excessive amounts on home loans. The Mortgages Directive was in the pipeline before the crisis, but it really gathered a bit of momentum after the crisis. It was finally passed last year. It actually was extraordinarily, excuse me, I have no idea what that did. It was finally passed last year. During the Irish presidency, incidentally, final agreement was reached, showing we are very good negotiators. It was very controversial. Again, the maximum harmonising attempt was what was holding things up to a large extent. Ultimately, what we ended up with was a directive which is maximum harmonising, but with loads of choice. So it's a maximum harmonising directive, but you've got lots of choice written into it. Department of Finance have produced a lovely consultation paper, and again, really useful to read because it sets out the choices. So any of you interested in this, I'll zip through it, because go to the Department of Finance page and you'll see a lovely list of all the choices which we have to make. And as to when we have to make them, incidentally, the Mortgages Directive has to be given effect, if I remember correctly, by the 21st of March 2016. So that's when that's going to be coming into effect. Okay, who does the Mortgages Directive, or what does the Mortgages Directive apply to? Credit agreement secured either by a mortgage or another comparable security on residential immovable property. But that, of course, has to be entered into by a consumer. Credit agreements, the purpose of which is to acquire or retain property rights. There's a list of exemptions, and then there's a list of possible exemptions. The first of these was a huge sort of sticking point, buy-to-let mortgages. And in the end, what the Commission did was it compromised, and it said member states can extend the obligations to buy-to-let mortgages and all of the others, or not. It's up to them. But they do have to introduce some legal framework. So there has to be a legal framework, but it's up to member states to decide whether or not the particular provisions of the directive should apply to that list of provisions, but buy-to-lets being the one that really caused the controversy. Okay, basic requirements in the directive. We're going to be getting more information. We're going to be introducing for the first time, well, kind of a right of withdrawal. As you know, at the moment, under the Consumer Credit Act, you can't withdraw from a home loan mortgage, although there are withdrawal rights in other situations. 7-day right of withdrawal, but if member states prefer, they can introduce that as a 7-day reflection period. So in other words, you agree in principle, but you have 7 days before the agreement finalises. Limits on tying of products, more creditworthiness and suitability requirements, but I think the Central Bank have that one covered before we get near the directive anyhow, if any of you have been following the 20% requirements and that. So, but lots more requirements on that. More regulation of credit intermediaries, quite a lot coming along the tracks there, and more provisions on arrears and foreclosure. So quite a bit coming out of Europe on that. Very, very quickly, Payment Accounts Directive. This was passed this July, I think, and has to be given effect within 2 years. Big things to watch out for. Requirements on comparability of bank account fees We're going to have to feed back a list of services to the Commission, and then everyone is, and they are going to issue a list of fees right across Europe. The idea is that we will all suddenly start deciding to use a German bank or a Greek bank or whatever rather than our Irish bank because the fees are better. Now again, how well that's going to work is going to be an interesting one. Switching requirements. So that's the comparability. Switching requirements. To be honest, there's not a whole heap there that isn't in our current code on switching. But the really interesting one, from my point of view at any rate, is this notion of access to a basic payment requirement, a payment account. Every member state has to establish or require at least one bank, which is not wholly online, to provide a basic payment account at low fees or no fees. And the idea there is to address social inclusion or exclusion, whichever way you want to look at it. That pretty much concludes all I want to say. For those of you who are interested in my little conclusion, which is really 3 extra bits, you can read it on the paper. So I'll now be quiet and hand over to Fidelma. Thank you very much.